And I think we'll go to Senator Hill for the first bill, Senate Bill number 2192. Senator Hill, you're recognized.
Thank you, Mr. Chairman. What this bill does is makes our driver's license statute consistent with statute 1-3-83 that the governor signed into law last year that basically says that sex is determined at birth. So that's basically what this does. It says that your driver's license or renewal of driver's license will reflect the sex that you were determined with at birth, and that a court order that's inconsistent with this subsection shall have no effect on the issuance or renewal of license under this chapter. And so that's all it does, is bring this into compliance with 1-3-83 that the governor signed last year.
All right, you've heard the explanation. Senator Hickman, for question.
Yeah, just a quick question. Are we requiring, like, I know it says renewals or duplicates. Are we requiring that at every renewal and duplicate that they collect? Like how are we determining this? Am I gonna have to show something every time I renew my driver's license other than my old driver's license to get them renewed or a duplicate license issued?
Likely, you probably won't. It's when there's a change on it that they're probably gonna ask for something, which they do now. If you look at their website, it basically says if you want to change it, that you had to provide X number of documents.
And my question is, I just think the language here, we say renewal and duplicate. So if I get a duplicate, that's nothing changed. But if someone has previously already had a court order, we're telling the Department of Public Safety that they need to do some type of research to figure this out. And so I think we put an onerous task on Department of Public Safety with this language.
Well, the Department of Vital Statistics has been changing birth certificates. And so with the passage of 1-3-83, we're trying to clean all this up so that they're all consistent with 1-3-83. And some may fall through the cracks, but if there's a change in the sex on a birth certificate, DPS is going to notice it, and they're going to look if we pass this law, because I'm being told now that they're changing them.
All right, other questions? If not, for motion, Senator Hill.
House efficient do pass.
For the motion, all in favor say aye.
Aye.
Any opposed, nay. The ayes appear to have it. The ayes have it. All right, Senate Bill number 2200. This was the Parker's Law, and this is the one that if you're selling fentanyl which results in death of someone, then the penalties are there. It had a repealer, which was, I believe, for this year. So 2200 removes the repealer on the Parker's Law bill. That's what this bill does. Any questions? If not, for motion, heard the motion, all in favor say aye. Any opposed, nay. The ayes have it. Senator Thompson, if you'll come on up and sit with us. Senate Bill number 2208. We've done this one a couple of times. I'm told our friends on the other end of the Capitol may be more receptive this year. They tell me it just fell through on a deadline day by oversight or something last session. So we are going to give it another shot. If you'll explain it to us, please, sir.
Sure. Thank you, Mr. Chairman. Thank you, members of the committee. Senate Bill 2208 seeks to amend the Mississippi terroristic threats law to provide an enhanced sentence for terroristic threats made against an airport. This stemmed from a couple isolated incidents, but there was no laws on the books to be able to prosecute those folks who made those threats. And so this makes that terroristic threat against an airport unlawful and prescribes a sentence for it. That's a brief explanation of the bill. I'm happy to answer any questions.
Okay, any questions for Senator Thompson? Senator Hickman?
Just one quick question. And I think I've supported this. I don't have any opposition to it, but you said that this is a couple of isolated incidents that's happened. Just out of curiosity for me, do you know, was there any prosecution? Did these people just get away, or did they prosecute them under some other statute?
I think there was just like a misdemeanor or something they were able to charge them with. There was nothing there. But yeah, it did pass last year, 51-1 out of our chamber.
Okay, any other questions? If not, for a motion, Heard the motion. All in favor, say aye. Any opposed, nay? The ayes have it. Thank you, Senator Thompson.
Thank you, Mr. Chairman.
All right. Next bill is actually authored by Senator Horn, but he had a death in the family. And so we're going to prevail upon Senator Sparks, the vice chair, if he wouldn't mind explaining and reminding us, this is a bill we passed last year as well, dealing with illegal dumping, Senate Bill 2308.
Thank you, Mr. Chairman. Senate Bill number 2308 simply raises the amount of the fine, I believe on line 42, from a minimum of 100 to 500 and to no more than 1,000 for 1,500. And that's for a small amount of trash that someone would dump. In subsection C, if it is exceeding 500 pounds or 1,000, or excuse me, 100 cubic feet in volume, it is again an increased fine, raising it from 500 to 1,000 and a max from 50 to 75,000. And it simply addresses illegal dumping and try to be a discouragement to that. And it is a bill, I think the chairman said, that we did pass out of the committee last year.
All right. Thanks for the explanation. Any questions for Senator Sparks? If not, for motion, Senator Sparks.
Title sufficient do pass.
Title sufficiently passes. The motion. All in favor, say aye.
Aye.
Any opposed, nay? The ayes have it. Next bill, Senate Bill 2329, the Giglio letter. Senator Sparks, if you'll explain that one to us.
2329 addresses a circumstance where a police officer would be put on notice by the prosecutor that they would be on a do not call list for not being a credible witness for some issues that may have arisen. It simply gives the officer the opportunity to respond to the terms that would create this prohibition of being able to be called as a witness. Of course, if you can't be called as a witness, you're not going to be able to serve as a police officer for very long. And it gives them an opportunity to address the prosecutor that believes that they have risen to the level of not being able to be called, and having a hearing with that prosecutor. If the prosecutor continues in his desire or her desire to put that officer on a do not call list, that they would have the ability to go to Chancery Court to seek injunctive relief or appellate relief. That is a brief explanation. I'd be glad to yield to any questions.
Who issues those, that call to begin with? Is it the prosecutor?
The prosecutor would be the one who, based on whatever evidence that they believe merits it, would put an officer on a do not call list, or what we call a giglio list, which means that they would basically not be able to be credible testimony. Any defense attorney in the world would say, this guy can't testify because he's been put on the list. So it just gives them a chance to address that before it happens. Otherwise, it's basically ending probably their career in law enforcement.
Senator Simmons?
Yeah, thank you, Mr. Chairman. I do have one question. What, if any, effect would it have on the defendant's right to call that person at trial?
In the sense of if I was put on a do not call list,
Yeah.
I don't, nothing. I think the
Okay.
defendant could still call them, certainly.
Okay.
Yes, yes.
Okay, thank you.
I think I saw another hand. Senator Hickman, yeah.
Just a couple of questions just to understand what's happening. So is this list housed only for that prosecutor's office that placed them on the list, or I'm sure everybody can get access to it if they know, but where are these lists housed?
In essence, it is that particular prosecutor that is putting them on a do not call list and making notification of it. But of course, if I've ever been put on a do not call list, I'm not going to be able to go to another district and convince a prosecutor, hey, I'm not, I'm not subject to that. In other words, you'd rather have a chance to defend against it before you were placed on the list.
And do you know how many instances, or like what led to this piece of legislation? How many instances are we having where people are being put on the list or and not having an opportunity? Because I'm guessing now, if you're placed on the list now, the prosecutor has to give you no notice, and then the only thing you can do is file for an injunction at some point, which is basically an equitable action in Chancery Court. That's how it works now. So how often is this happening?
I do not know as far as statistically nationwide or by state. I'll be glad to ask under the circumstances. Of course, Giglio is the United States Supreme Court decision that that brought this about, that created this to obviously protect a defendant from having someone testify that's not credible. But this is simply trying to make sure that someone is not deemed non-credible without having an opportunity to respond.
Thank you.
Thank you.
Senator Simmons.
Thank you, Mr. Chairman. And so that's the reason why I'm glad that you actually said that it does in fact, will not really infringe on the right of the defendant. I guess that's good to know, because to the extent that an officer is in fact placed on the list, I can see a defendant who is charged or accused of a crime by virtue of an officer being placed on the list may in itself serve as evidence in that particular defendant's trial, to the extent that officer was involved in any way in that particular prosecution.
That's
So-
correct.
So, okay,
Yeah.
thank you.
Thank you.
Senator, yes, Senator Wiggins, Chairman Wiggins, sorry.
Thank you, Mr. Chairman. So, I just want to make sure I understand what this is. If Senator Barrett can move over.
Mom
So,
and Daddy weren't glass makers, were they?
right. Is this in any way, affecting the prosecutor's or a DA's office's ability to decide whether the witness can be called or not called?
No, I think the prosecutor, you always have the opportunity to make the discretion of who you would call in your case in chief. But this is a circumstance where you would make notice to everyone, including the defense, that Officer Jones is on the do not call list. He's not able to be called in this case because we find him non-credible. So it does not limit the prosecuting attorney's ability to call whomever they want to call to make their case in chief.
I got you. And to be clear, the prosecutor's office or DA's office makes the decision, whatever the case may be, whether that officer is credible or not. This is saying because of specific circumstances, they have to notify both the officer and the defense. Is that right?
Well, in this case, they're notifying the officer that there is a intent to place you on a do not call list, not for this case, but for,
In
I'm
general.
not calling you. I find you not to be credible. And once you end up on that list, your career in law enforcement's over. It gives the officer an opportunity to have a hearing or meeting with that prosecutor, and the prosecutor say, this is why you're going on the list, in my opinion. And if the officer in the hearing is able to convince the prosecutor not to put him on the list, then he doesn't go on the list. If the prosecutor says, no, I'm not continuing with you, I'm going to put you on the list, he would have the ability to go to Chancery Court.
And those decisions are for a prosecutor would make that decision about putting somebody or an officer on the giglio list to ensure justice. I mean, they found some reason why this officer shouldn't be trusted or whatever. Is that right?
Well, that would be what we would find out if they have a hearing, but just to arbitrarily say, I'm going to put Officer Jones on the giglio list, now his career is over. He may not know the basis of what you've used. So it's just tell me what the basis is that you're saying that I should not be able to testify and or be called anymore, and basically end the career in law enforcement. And if you persist in that, you have the right to do that as the prosecutor, and it may be justified.
Okay. And looking at line 73, that's where if after the hearing, the decision is made and then there's notice allowed
That's correct.
and appeal if they feel it's necessary.
Yes.
Okay. Thank you.
Thank you.
All right, any other questions, comments? If not, Senator Sparks for a motion.
Title sufficient do pass.
For the motion, all in favor say aye.
Aye.
Any opposed, nay? The ayes have it. I think I skipped one of the bills, so we'll go back to it. Senate Bill 2314, dealing with controlled substances law and putting hemp products on Schedule 1. Senator Sparks.
Thank you, Mr. Chairman. This bill, it's very simplistic in what it does. In line 319 through 321, this is existing language. There was a lot of debate last year about hemp, about products in convenience stores, and could they charge, could they not charge for a crime, and a lot of consternation. But if you look at what is existing law, the exemption from controlled substance is the word, or the words on 319 through 321. Any product derived from the hemp plant designed for human ingestion or consumption that is approved by the United States Food and Drug Administration. So if it is derived from the hemp plant and it is designed for human ingestion or consumption, and it has the United States Food and Drug Administration, it is exempted from control, meaning it is not illegal. I repeat that, or the legislation repeats that language on lines 265 through 268, 272 through 274, and 315 through 317 to clarify that if you have a product derived from the hemp plant for human ingestion or consumption, and you have a United States Food and Drug Administration approval, that it is not a criminal item. That's all it does.
Okay. Questions? Are there any products currently that we would see in the local stores that this would apply to?
Well, I mean, if it's derived from the hemp plant and it's sold for human ingestion or consumption, then it would need a United States Food and Drug Administration approval. I don't know which ones do and which ones don't.
Yeah. So I'm just wondering, are there products that we would normally see walking into a normal store that this would fall into, like that we?
I think a lot of the products that you see in a convenience store up front are marketed to be inhaled, ingested, consumed, and they are marketed to be derived from the hemp plant. And they're just as fine as they can be as long as they meet this criteria, which is existing law. So I've just repeated existing law 3 times to make sure it was clear.
Okay. Any other questions? If not, for motion.
Title sufficient, do pass.
Heard the motion, all in favor say aye.
Aye.
Any opposed, nay? Yeah, I believe the ayes have it. The ayes have it. All right, Senate Bill 2347, methamphetamine, revising the penalty for simple possession of certain amounts. Senator Sparks.
Thank you, Mr. Chairman. Pertinent language in this bill is on line 248 through 283. I had dropped this bill a couple times over the years. Currently, the law is that if you have 1/10 of a gram up to 2 grams, it is a 3-year crime of the possession of methamphetamine. Methamphetamine is a very, very serious drug across this state, particularly in my region. I see a ton of cases, backs up the crime lab, et cetera, et cetera. The concern that I have is I've seen a lot of felony cases indicted, meaning the prosecutors take the time to present a case to the grand jury, indict the case on a 0.17 grams, a 0.22 grams. And those cases are usually going to end up in diversion, but yet we're using the crime lab. We're using the resources of the state. And the delay in the crime lab getting results usually means I'm a year or greater until I'm indicted. So if somebody's using methamphetamine, I've never met a casual methamphetamine user. They have a problem. If I can get them into misdemeanor court, into justice court, into municipal court, and usually that's within a matter of a couple of weeks, that it would be better for these very small amounts to be utilized as a misdemeanor, where a first offense is punishable by 30 days or a $250 fine, or both. A second offense within 5 years would be a $250 fine, not more than $1,000, not less than 5 days in jail, not more than 6 months in jail. And a third offense within 5 years would in fact be a felony and would be a 5-year crime. In addition to that, the court shall require the defendant to participate in a drug education program approved by the Division of Alcohol Drug Abuse. The point of it is, if I can get you into court quickly, and maybe you are at the beginning, you've not committed a property crime, you've not committed some other offense, that we can address it at the misdemeanor level. Additionally, from 1 gram to 2 grams, it raises that threshold from a 3-year crime to a 5-year crime. The biggest reason there is that we have a lot of people from 1 gram to 2 grams who will not get into an intervention court because intervention court has 5 years of jurisdiction. So because it's only a 3-year crime, some people will not allow them into intervention court. So that is an explanation of the bill. There is a repealer in this bill as far as this section, because like I said, this is language I've used in the past, but I would yield to any questions, Mr. Chairman.
Senator Hill?
Make sure I understand this. So between 1 and 2 grams, you're strengthening the penalty.
That's correct, yes.
And less than a gram, you're dropping it to a misdemeanor.
That is correct. But if you stack if you stack 3 offenses of that lower level, it becomes a felony on that 3rd offense within 5 years.
How long do you think it would take 3 misdemeanors to clear 3 convictions in a municipal court? How long do you think it would take 3 misdemeanors to clear in a municipal court? Because you would have to have 3 convictions, not 3 charges, correct?
That is correct. That's
So
correct.
what's your estimated time frame for them to get to a felony with under a gram?
Of course, I'm guessing.
Just guess.
Right, but from what I've seen, you catch somebody with an amount of methamphetamine, if you want to catch them again, you catch them pretty quickly because nobody's using it casually. So I see it a lot.
I'm just wondering if those municipal courts are as backed up as some of these other courts on these felony cases.
No, ma'am, they roll them.
So they would roll a little faster.
They do.
Thank you.
Thank you.
Hickman?
Senator Sparks, just was wondering, was there any consideration? I don't know if a such thing exists, but I do know that I think most courts, any DUI that you get, they make you do a program. Was there any thought to, after that first misdemeanor offense or the second one, to require some type of program or education or prevention at that point?
Yeah, actually, and I'm glad to work with you to clear that language up, but the court, if you look on 261 for a first, 260 and 261, for a first or second offense under this item, which be the misdemeanor, the court shall require the defendant to participate in a drug education program. I'm hoping to work with our regional, mental health centers, the region, all that to try to, or community health centers, to try to address this, because that's what you need. And I've even, if you ask me, what do I envision? Okay, I got 30 days in jail. In lieu of 30 days in jail, you shall have an assessment. And I think the judge can do that because it may be that the assessment helps you know what you need to do. A second offense, 6 months in jail, or you can complete 30 days of inpatient. That's what I'm going toward. I think is what you're saying.
That's exactly what I'm saying.
Yes.
And I think I thought, and maybe it was the way it came to, I thought that would require them to have the 3rd offense, but now I see what you're saying.
Yes.
I think we could maybe strengthen that. So, or talk and make sure they develop a program, kind of like, the program with the DUI and stuff. It's a developed program.
Yes.
It's a set curriculum, and maybe we can work on something like that.
Glad to work with you on that.
Senator Wiggins, did you have a question? Senator Suber.
Thank you, Mr. Chairman. Senator Bear, would you skip back a little bit so I could see? Senator Sparks, I appreciate your legislation. My question is, on the 1 gram or less, what's typically happening now in the circuit courts when the courts have a defendant that has less than a gram?
They're generally going to offer them diversion, but it's going to be after they have presented it to the grand jury, which is a lengthy wait, which unfortunately they probably stacked some other crimes up. So the goal is to get them to court quickly.
Well, if they're not doing the diversion, they're either reduce it to misdemeanor
That's correct.
anyway or dismissing
That's
the
right.
case altogether. So but with this, it looks like, they're going to actually get some help, maybe go to a class to maybe rehabilitate them, maybe get them off the substance they're on.
That is 100% the intent. Yes.
All right.
Thank you.
Thank you.
Senator Simmons?
Thank you, Mr. Chairman. I kind of have a question and if you would indulge me to explain it, start at line 204. Is the levels of marijuana, and this is simple possession only, not intent to sell or distribute. And I guess I'll first ask Senator Sparks. Our current law, up to 30 grams of marijuana is a misdemeanor.
Correct.
And at line 205 to 211 is the part of the statute that allows 30 grams of marijuana to 250 grams to be treated either as a misdemeanor or felony. Do you agree with that?
I would say that that's how it reads because it's confinement in the county jail for not more than 1 year, which I don't know that we ever have defined misdemeanor and felony in the statute,
Yep.
but that's the definition we go by.
And so when someone has that range between 30 grams and 250 grams, according to the way the law currently is, it could be treated as a less than 1 year or up to 3 years or $3,000 fine, which of course over 1 year is a felony.
That is the way I read that section of current law.
Okay, and so my question is, as this bill moves through the process, I guess first to you and then also then to the chairman, would you be willing to look at this statute too, in light of where we are regarding medical marijuana in the state of Mississippi, and as currently written this small amount of marijuana, looking at how we could change the penalties here and or raise the limits of the amount that is possessed that could be a misdemeanor?
I'm certainly glad to have any conversation with you.
Okay.
And I understand your point, and I don't know how many people take the option to prosecute under either or.
Yeah.
But I'll be glad to chat with you.
And to be clear, I'm not talking about what is clearly in the statute as felony amounts. I'm only talking about in the spirit of the proposal that's before us regarding smalls amount of meth, if we could also look at smalls amount of marijuana as this bill goes through the process.
And I certainly will. The only thing, and I'll have to admit, I'm not much of a meth or marijuana user, but if it's under a gram of meth, I'm pretty sure that can be gone in an evening. I'm not sure somebody can smoke 200 grams of marijuana in an evening. So I think part of it has to
depends on who you are,
be-
Senator Smart.
That depends on your equipment, I guess. Yes. Thank you.
Thank you. Thank you.
And would, Senator Simmons?
Yes, sir.
In your proposal, should it come, would it be similarly related to the intent of the current proposal to get that person treatment?
Absolutely. But I just know that the way that law is currently written, even though this is a small amount of marijuana as recognized by the people in this building at some point, that range should be treated as a misdemeanor or felony to the extent someone is experiencing a problem. Let's try to give them the same type of assistance and help that we are considering for people who are on meth. Yeah.
Gotcha.
Thank you.
Senator Hill?
Just one more question. I don't remember you addressing the 2 to 10 and then greater than 10. Are those two increased as well? The 2 to 10 and the 10?
I
10
think
to
that is
20?
existing law. I don't.
Okay, because it's all underlines why I'm asking.
Well, it's because they broke out, and I'll double check that for
Okay.
you, Senator, but they broke out methamphetamine into separate lined areas, but I will double check
So
that.
you
but
think the only thing changed is less than 1 and 1 to 2?
that was the intent? Yes.
Okay, thank you.
Thank you.
It's Senator Wiggins.
Thank you, Mr. Chairman. Few questions. So meth, as you said, from my understanding, and not that I've done it obviously, but is very addictive and thank you, Senator. Highly addictive, which is why we've had the higher penalties. But your point about getting treatment is what is very accurate, because the sooner you get them treatment, the sooner we can get to the problem. So just going through it, first out in line 106, which is the simple possession, this statute states that if you don't have a prescription, that's when it's illegal. Do we do prescriptions for methamphetamine?
Not that I'm aware of.
Well, that's why I don't know what this would fall under, because if you look at it, it says it's unlawful, in short, without a prescription. And then it goes on to say marijuana and methamphetamine. So we're basically doing a negative, saying you can write a prescription for methamphetamine. Have we thought about that?
I am glad to get with legal and see if that's their reading of it. Obviously, again, I don't think anybody's going to write a script for methamphetamine, but that was not the intent.
Okay, so there's that. And then, so I understand in line 261, if I understand, if there is I'm sorry, in line 261, there has to be whatever resolution, there has to be a drug and alcohol program that the person has to be sentenced in.
Yes.
Is that right? So, and this is my concern. If you're in misdemeanor court, I don't know whether it's city court or justice court, many of them that either have a drug court program. Okay. That have a drug court program or something. Usually what I've seen is they go, okay, you get, we suspend your sentence for 30 days. And then if you mess up, you come back, we don't put them into a drug program. But you're saying under this, that if it's charged that way and it's resolved through plea or something, they have to be put into a program.
Yes, if it's a conviction, yes.
Okay. And so across the state, I'm just making something up, but in Vicksburg City Court, will they be able to put them in a program there?
I'm leaning on our community mental health centers, the Region 4, if I'm using the right terminology, up in my area, and other places such as that who do this kind of work already, Communicare, over in the Lafayette County area. Those organizations would be the ones that I would say would be most apt to be utilized, because that's who our courts use today in most of these circumstances, even on the circuit side.
So, okay, so they would be, they would be sentenced to attend a program at the community mental health center.
Well, they
for
would be,
drug.
sure, they would be
addiction.
sentenced to attend it. Now,
Right.
if they have something somewhere else that is acceptable to the judge, that's fine. I'm not trying to lock them into it. It is just a program that's approved by the folks at mental health, because I think that, they should be the gatekeeper of whether it's a good program. or
Yeah,
not.
you're right. So in my area, sometimes there's places in the churches and
Right.
the
If it's
judges
approved,
will
that's right.
say, to go to this place. So the bottom line is with that amount, they have to go to some kind of drug program sentenced by the judge.
That's correct.
Okay. No. And the problem that you're trying to, so let's say there's 0.1, if my numbers are right, 0.15, that would be under your bill, that would be a misdemeanor.
That's correct.
Okay. Right now, if it's a 0.15 in many places across the state, it's indicted as a felony. Is that right?
That is correct.
Obviously.
That's correct.
And so then that means that, like you said, they either go into diversion or something.
But that's after you wait on a crime lab. And
Right.
after you present to the grand jury, you can't go to the grand jury without a crime lab. And what we're really trying to prevent is this person stacking more charges, ultimately a property crime, because if you are using methamphetamine, eventually most people are going to run out of funds, then they're going to beg, borrow, steal, and the steal part gets us new felonies. And we're trying to get you to someone sooner.
How many, just ballparking, how many indictments, let's say, of like 0.15 gram or under that, just alone end up going to prison? That you know.
Will end up going to prison if I plead guilty on a 3-year crime and then I violate because I never got any treatment. I just
If
went
you
there and
violate,
pled,
right,
and then I'm going to prison. So I would say a lot of them.
because they're violating on the
That's
probation.
correct. They may not be sentenced. The judge could sentence them right out of the gate on the first.
Even a
offense.
first-time offender?
They could. I mean, that's what the statute allows. It's 3 years incarceration.
Right. So it's getting, they call it swift and accountability. So if we can get them swift and accountable, resolution, then it's going to take more so as what you're describing is by the time it goes to the crime lab, it does all that, it's going to be 9 months or something. In the meantime, they're off in other problems.
That's correct.
Okay. All right.
Especially in the rural areas where grand jury may not meet but 3 times a year.
Okay. So, okay. So how did the, if it comes back, well, that's okay. I got it. Thank you.
Thank you.
Okay, good questions. Anybody else? Senator Hill?
It's just going to clarify that there is prescription methamphetamine listed on the DEA's website to treat ADHD and obesity, but it's only one.
All right, seeing no other questions for a motion?
Title sufficient do pass.
Motion is title sufficient to pass. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. All right, thank you, Senator Sparks, for your explanations. We're going to jump down to the last one and come back. Senator Robinson is joining us today. We're happy to have you. If you'll explain your bill, Senate Bill 2833, please, ma'am.
Thank you, Mr. Chairman, and thank you for the opportunity to talk about 2833. I currently serve as Vice Chairman of the Joint Legislative Committee on Performance Evaluation and Expenditure Review, better known as PEER Committee. This committee provides the legislature with information on state government to aid in the legislature performing its function of legislative oversight. Also, PEER analyzes state agencies and programs and operations to help the legislature in making state government more efficient, more effective, and accountable. So to that end, Bill 2833 provides criminal penalties for persons who fail to comply with the subpoena for PEER committee and for civil enforcement of those subpoenas. The legislation would also enable the Sergeant of Arms of the Senate to serve PEER committee subpoenas. Now, currently, PEER has subpoena power, but enforceability has been a problem. The current statute establishes no penalty for contempt by persons who fail to honor that subpoena. Further, there's no civil enforcement mechanism. So this bill, Bill number 2833, establishes a criminal penalty consisting of fines and incarceration. And the fine would be not more than $1,000 or no more than 6 months in jail or both. Secondly, it would provide for civil enforcement of the subpoena through Chancery Court. The third thing the bill would do would be provide that persons who respond to PEER subpoenas do not receive immunity like they do currently with a legislative subpoena. And the fourth thing that this bill would do is provide that subpoenas shall be served by the Sergeant of Arms of the Senate. And Mr. Chairman, that's the bill.
Thanks for the explanation. Are there questions? Anyone? Senator Sparks?
Thank you, Mr. Chairman. The 112 through 117 references back to the immunity given under subsection 1. And this probably is more of a question for legal, but
Thank you.
I would just want to make a point to be concerned that if someone testifies, writes a book, document paper, they're losing their immunity. I think they're just need to make sure that that's not a First Amendment issue, and it's also not a kind of a conflict issue there. I just don't understand how you lose your immunity if you had it and then you testified to something. So just I would just ask legal maybe to look at that as we move through the process.
Thank you. I sure will.
All right, other questions? If not, for a motion?
Title sufficient do pass.
All right, the motion I'll make is title sufficient to pass. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you so much. And our final bill for this afternoon, of course, remember we're meeting again in the morning, so for a brief interlude here, Senate Bill number 2796. And this one is Senator Williams' bill. Senator Williams, please come join us at the table if you would and explain this particular bill, please, sir.
Thank you, Mr. Chairman. Thank you for members of the community to have me. This bill is known as the Ensuring Likeness, Voice, and Image Security Act of 2025. It's also been called the Elvis Bill, and it's modeled after the bill that Tennessee did. As you know, the advancement of emerging technologies, particularly artificial intelligence, the ability to capture these things about people, their voice, their image, and their likeness becomes more and more realistic. So this is a piece of legislation that will guard against that. With that being said, it's a piece of work, and I'm asking for us to pass this forward if we could. Since we've started working on this, the representatives of the Motion Picture Association and the Recording Industry of America are working on some language that they're about to agree on, and we want to take a look at that and probably incorporate that in this bill. At this time, I would yield for any questions, Mr. Chairman.
Thank you, Senator Williams. So there's a proposed committee substitute. Are you looking at that one or are you looking at the?
I do not have the sub.
Okay, so I'm going to ask Ethan, if you will, can explain the difference between the original and the committee sub?
Is this?
Sure. Thank you, Mr. Chairman. The proposed committee sub is amend subsection 3 of section 7 to include cable providers, producers, programmers, streaming platforms, mobile applications within the fair use exemptions. And it also removes a phrase at the end of the bill that said, unless it is established that such owners or employees had knowledge or reasonably should have known. So it removes that and it adds in cable providers.
Okay, I'm aware of that. I have no issue with that.
All right, Senator McCon.
I've just got to ask a few questions here for clarification. There's not a first repealer on this, is it?
There is not, and that's probably a good thing to add right now.
I think, Mr. Chairman, I will have a motion at some point to add
Let's
that.
go ahead and do it.
Let's go ahead and do that. I'd move for the addition of a reverse repealer on this bill.
All right, you've heard the motion. Any questions on the motion? Not, all in favor say aye.
Aye.
Any opposed, nay? The ayes have it.
So just for clarification, we're all in the legislature. We all have to run every 4 years. Am I going to start taking waivers to every event that I take a photo at?
No, I think there's some exemptions in there that speak to,
Can you tell me where they're at?
photo.
Because I tried to look at it. I wasn't trying to, I think this is great because as a whole, AI and everything else out there is destroying society as a whole.
Yeah, I apologize. I've looked through this, but I didn't make notes of where it is. Line 173, in connection with any news, public affairs, or sports broadcast or count. Starts at section 7, I think, and if that's something we need to work on and tighten up to make sure, because you're right, as we go down the path of looking at artificial intelligence, what we don't want to do is cast a net that catches things we don't want to catch.
All right, so you say there's some, and I will continue to read that now that we've got a reverse.
And I'll come back to you, Senator, with that as well.
The other question I would have, I would suggest you look at lines 82 and 83 with regard to, and I believe that's what it is. That was in section 5. When you define who can give consent for a deceased individual, you note heirs, devisees, people like that. As an attorney who practices in this area, you're opening a can of worms because one person could consent and nobody else wants to consent. I think you need to maybe tighten that up just a little bit.
If there's a way to do that, we certainly will.
I would suggest you do that because I think it's going to open up a can of worms there. So that's all my questions, Mr. Chairman.
Thank you for the advice.
Thank you for the questions. Senator Hickman.
Thank you. Just a couple of questions. So this creates civil cause of action as well as criminal causes, because I think it says something about like a class A misdemeanor in
Yes.
here. So it does both.
Yes.
And so if it's does it have there's no felony penalties in here, is there?
I do not believe so, no, sir.
So what thought was given to Section 6? Why do we give jurisdiction to both Chancery and Circuit Court as it relates to the civil, or whatever arises out of this? And my asking of that is that we could have, I guess, purely left it in Chancery or purely left it in Circuit, since we only have a misdemeanor, the criminal penalties would never really rise to a Circuit Court level. So what thought was given to giving both courts jurisdiction here?
I'm not sure of the original reasons for that. My assumption would be, could it be that the severity of the breach? I mean, if it's a smaller judgment versus what might be a larger judgment. I mean, if you're looking at the Elvis bill, obviously, if somebody takes his voice and feeds it an AI model and capitalizes on that.
Okay. But and my only thing is, we're having some side conversations. The difference in mine. My only thing is that, which I guess is fine. If I'm bringing a case, it allows one to venue shop wherever they want to go to. Like if we have a chancellor in our jurisdiction that's given higher reward, then we go there. If we have a circuit court judge in our district that's given higher rewards, then we go there. Or
Understood. I
vice
think as this
versa.
thing goes through the process, these are some of the things that we'll see refining and tightening. Senator McCon said a moment ago, and I'll definitely solicit the expertise in this room to help work this.
Okay. Were you finished, Senator Hickman? Were you done? Okay. Senator England?
Thank you, Mr. Chairman. And I wonder, and Senator Williams, you may not know, but I just want to ask the committee and legal can maybe address this. If Chancery was maybe referenced in the event that there was a settlement of an award involving a minor, I believe that the Chancery Court would be the venue to handle it in that instance. Do you know?
I do not know. That's logical, but I do not know.
Okay, well,
I'll try to find that
but
out.
also could probably use some clarification language. Okay, yeah. Right, so injunction like, right. So I think that.
Yes, sir.
But I did want to ask the intent of the bill. When I attended a meeting in Washington DC several years ago, one of the issues that we had was there's a politician in Florida that has been involved in a deep fake where it looks like she's the individual that's the subject of a pornographic video.
Yes.
And she could not remove that from, it was my understanding that she could not remove that from the internet because she didn't actually own the deep fake. And that's kind of what we're getting at, because it was her likeness, but it was not her property. She was not the owner of the digitally created image. So is that one thing that you're trying to address here?
Yes, it is. I think it's what the intent that the creator of the media is going to do. I mean, if it's for commercial gain or if it's to defraud the individual, I think that goes back to the conversation here. And there are a couple other bills out there working. One's an elections bill, I think, with deep fakes. And as we go through the process this year, we may end up with a bill or a couple bills as this kind of evolves. Obviously, the legal piece is where I need more help. Trying to understand the technology is probably where I'm okay.
Okay, thank you, Senator Williams.
I think Senator Barrett had the next question.
Thank you, Mr. Chairman. Senator Williams, thank you for your work on this bill. I understand that Tennessee and maybe a few other states have passed this. Are you aware if there are some federal movement on this at this time?
I'm not sure if there's specific movement. There is some things that there is an expectation with the new administration that there might be more of omnibus bills in this area, and the artificial intelligence is a whole area, and which I think would be good if that does happen. That way we don't, quote, piecemeal it in the state area. So we're hopeful for that, but I'm not aware of specific legislation at this point.
Thank you.
I think someone over here, was it Senator Simmons? Yeah.
Just one quick question, Mr. Chairman.
Take all the time you need.
Thank you, Mr. Chairman.
We're here to listen and learn.
Yeah, I was looking at line 105, and I think this question has been raised about establishing criminal penalties.
Yes, sir.
And it's more so to the lawyer, Senator. Is Class A misdemeanor defined under the code?
That was a drafting error.
Okay.
From another state, so we don't classify by classes.
Okay, yeah, all right, thanks.
We'll take it out. Do what? Just the class A.
Look at what a class A was in that state.
Did I miss somebody else's hand?
Don't make the motion. I'm not on the committee.
Chairman Wiggins.
What motion I make?
Okay, anybody else? I don't want to overlook anyone.
Title sufficient to pass.
All right, if not, then,
Sufficient to pass.
the motion is title sufficient to pass is it as amended? Yeah. Oh, committee sub, sorry. I'm sorry. I sit corrected. All right, all in favor, say aye.
Aye.
Any opposed, nay? The ayes have it. All right, motion to rise and report. We'll see
Thank
you
you, Mr.
early
Chairman.
in the morning. Talk to witness. Well, because you.